Welcome to the Divorce Lawyers podcast, where we delve into the complex and ever-evolving world of family and divorce law in Ontario, Canada. I'm Deepa Taylor, and we're your guide through the intricate legal landscape that affects families across our province. Today, we'll be exploring a fascinating and increasingly relevant topic: the intersection of fertility law and family law. Fertility law is a relatively new and specialized area of practice, but its implications are far-reaching, especially when it overlaps with family law issues such as separation, divorce, and the rights of parents and children. So, what happens when a couple who has undergone fertility treatments decides to separate? Who has the legal right to embryos? What happens when donors or surrogates are involved? These are just a few of the questions we'll explore in today's episode. We'll also dive into the legal frameworks governing fertility in Ontario, the challenges couples face, and some real-life cases that highlight the complexities of these issues. Whether you're a legal professional, someone navigating these waters, or just curious about the topic, there's a lot to unpack. So let's get started. To understand how fertility law intersects with family law, we first need to grasp the basics of what fertility law entails. Fertility law covers a broad range of issues, including assisted human reproduction, AHR, which involves procedures like in vitro fertilization, IVF, surrogacy, sperm and egg donation, and the legal agreements that accompany these processes. In Ontario, and indeed across Canada, fertility law is governed by both federal and provincial legislation. The key piece of federal legislation is the Assisted Human Reproduction Act, AHRA, which was enacted in 2004. This act outlines the legality of various fertility practices, such as prohibiting payment for sperm, eggs, or surrogacy, and emphasizes the need for informed consent in all reproductive procedures. At the provincial level, the Children's Law Reform Act, CLRA, is essential for determining parentage in cases involving assisted reproduction. It sets the framework for who is considered a legal parent and under what circumstances. Understanding these laws is crucial for anyone involved in fertility treatments, as they define the rights and responsibilities of all parties involved, including intended parents, donors, and surrogates. The journey through fertility treatments is often an emotionally charged and complex process. It's not just about the medical procedures, it's about the hopes, dreams, and sometimes the heartbreaks that come with trying to build a family. When couples undergo fertility treatments, they are often required to make difficult decisions that have long-term legal implications. For example, couples must decide what will happen to any remaining embryos if they separate or divorce. These decisions are usually documented in consent agreements, but as we'll discuss later, these agreements can be contested in court. The stress of fertility treatments can also strain relationships, sometimes leading to separation or divorce. Statistics show that infertility affects 1 in 6 couples in Canada, and the process can be fraught with emotional challenges. Couples may experience grief, guilt, or blame, which can exacerbate existing tensions in a relationship. This brings us to an important intersection between fertility law and family law. What happens when a couple undergoing fertility treatments decides to separate? How are the rights to embryos, sperm, or eggs determined? And how does the emotional toll of infertility impact the legal proceedings in a divorce? Now that we've discussed the emotional and relational aspects of fertility treatments, let's dive into the legal frameworks that govern these processes in Ontario. The Assisted Human Reproduction Act, AHRA, is the cornerstone of fertility law in Canada. It criminalizes certain activities, such as paying for surrogacy or donating sperm and eggs, to prevent the commercialization of human reproduction. It also establishes strict rules around consent, ensuring that all parties involved in reproductive procedures have given informed consent. In Ontario, the Children's Law Reform Act, CLRA, plays a pivotal role in determining parentage in cases involving assisted reproduction. For instance, the CLRA states that a person who donates sperm or eggs using assisted reproduction is not considered a parent of the resulting child. This provision is crucial for donors who do not wish to have legal or financial responsibilities for the child. However, the situation becomes more complex when considering surrogacy or the use of donated embryos. The CLRA also outlines that the birth parent is considered a parent, unless the child is born via a surrogacy agreement, in which case the intended parents become the legal parents. This is conditional on the surrogate providing consent after the birth. One of the most challenging areas of fertility law is determining what happens to embryos when a couple separates. In Ontario, the law is clear that embryos are not considered property and cannot be divided like other assets in a divorce. Instead, their use is governed by consent agreements made at the time of creation. But what happens if one party withdraws consent after separation? We'll explore that next. Let's turn our attention to some real-life cases that illustrate the complexities of fertility law and its intersection with family law. One of the landmark cases in Ontario involved a couple who had undergone IVF and created several embryos. After their separation, the wife wanted to use one of the remaining embryos to have another child. The husband, however, did not consent, leading to a legal battle. The court ultimately ruled that both parties' consent was required to use the embryo, emphasizing that embryos are not property and cannot be unilaterally used by one party without the other's consent. Another interesting case involved a posthumous sperm retrieval request, where a widow sought to use her deceased husband's sperm to conceive a child. The court had to consider whether the deceased had provided clear consent for his sperm to be used after death. The court ruled that without explicit consent, the sperm could not be used, highlighting the importance of clear and documented consent in fertility law. These cases underscore the critical role that consent plays in fertility law and the legal challenges that can arise when relationships break down. They also illustrate the importance of having clear legal agreements in place before undergoing fertility treatments, as these agreements can be difficult to enforce or change after separation or death. Given the complexities of fertility law and its intersection with family law, what are the best practices for couples considering or undergoing fertility treatments? First and foremost, it's crucial to have clear, legally binding agreements in place before beginning any fertility treatments. These agreements should outline the rights and responsibilities of each party, including what will happen to any remaining embryos in the event of separation or divorce. It's also essential to understand the legal implications of using donors or surrogates. While donors typically do not have parental rights, there are exceptions, especially if the donor has a relationship with the child. Surrogacy agreements must be meticulously drafted to ensure that all parties' rights are protected, and the process complies with both federal and provincial laws. For those considering fertility treatments, it's advisable to seek legal counsel from a lawyer who specializes in both family law and fertility law. This ensures that all legal aspects are considered and that you are fully informed of your rights and obligations. Finally, communication and emotional support are key. The journey through fertility treatments is challenging, and it's important to maintain open communication with your partner and seek support from professionals if needed. Fertility law is a complex and evolving field, and its intersection with family law can create challenging legal and emotional issues. As we've discussed today, the key to navigating these challenges is understanding the legal frameworks that govern fertility treatments, having clear agreements in place, and seeking professional advice when necessary. If you're facing a situation involving fertility law and family law, remember that you don't have to navigate it alone. Legal professionals specializing in this area can provide the guidance and support you need to make informed decisions. For personalized guidance, please consult one of our lawyers by visiting DivorceLawyers.ca. Thank you for joining me on the Divorce Lawyers podcast. I hope today's discussion has provided you with valuable insights into the intersection of fertility law and family law. If you have any questions or topics you'd like us to cover in future episodes, please reach out. Until next time, take care and stay informed.